You're listening to God, Law, and Liberty with David Fowler and Gary Humble. We're putting culture on a collision course with the truth.
All right, welcome to another episode of God, Law, and Liberty. I'm Gary.
And I'm David.
And it's so good to be back with you. You know, we've been off for a bit. We had the holidays and the New Year. And then me personally, David took a trip to see some family. And then I've had a 4-week bout of the flu, followed by acute bronchitis, and now a sinus infection. So fun times.
Yeah. We actually tried to record a show in there, and you sounded like the guy in those old commercials that coughed so much, you know, that he had emphysema or whatever. It was
pretty bad. No, seriously, no one wanted to hear that. So it's been deleted.
Well, let's go today. We got some really good stuff to talk about.
We do. You know, so you sent this letter, David, that everybody's freaking out about to all 95 county clerks in the state of Tennessee,
right.
Letting them know that essentially they're not upholding their duties under the Tennessee Constitution. And that's made some rounds in gay news outlets across the country, as well as several newspapers. And I think Channel 4 here, local Nashville news, has probably run a story today or tomorrow. But
right.
So one of the, as we've put this out there about the fact that, the Tennessee Constitution, the portion that licenses marriages, which essentially says that any marriage license that doesn't, promote the definition of a traditional marriage as one man and one woman, essentially shall be null and void.
That's right.
Void and unenforceable.
Yeah, any law purporting to define marriage as other than a man and a woman is void and unenforceable.
Yeah.
Right.
So we've kind of put that out there, and of course the naysayers and folks on the left and all that stuff, the argument that continues to come back is, well, you guys are idiots, don't you know about the Supremacy Clause? Yeah. And so one of the things we want to talk about today is why the Supremacy Clause is really not an argument you can make in what we're discussing here, because essentially, and I'll let you explain the details, obviously, but essentially the point that people miss is that courts don't make laws. And we've talked about that quite a bit on some prior episodes. Courts don't make laws, and the Supremacy Clause has to do with one law being supreme over another, not the judgment of the court.
Right.
And so,
right.
Can you explain that?
Yeah, we need to talk about it, and this is almost one of those cases where a little bit of learning is almost dangerous, because we've all heard of the Supremacy Clause. We've all heard that federal law trumps the state law. The U.S. Constitution is the supreme law of the United States, and that's what gets thrown in our face. But we've also learned, as far back as, at least in my case, 8th grade civics class. Now, that was 1971, I guess, but courts don't make laws. Legislative bodies make laws. Courts interpret the law, and the reason they interpret the law is in order to issue a judgment to resolve a dispute between particular parties. So we have a statute that provides for something, and you and I get in a fight over what's supposed to happen. You sue me, I sue you, we sue each other, and the court has to say, well, what does this law mean? How does it apply to this dispute between the two of them? And so they enter a judgment. Now, that's not a law. It's a judgment. So if you have a similar dispute with another party, you can't just walk over to them and say, hey, I won in this lawsuit against David. He owed me $2,000. You owe me $2,000. They say, well, wait a minute. I didn't get my day in court here. There's some different facts over here. Mm-hmm. David Fowler's ugly and I'm handsome, and that should make all the difference, right? And so judgments are not laws. That's the first thing we got to remember. The second thing is, what does the Supremacy Clause apply to? It applies to only 3 things. One is United States treaties. Well, that would be pretty obvious. The United States treaty would, trump something else. So if we sign a treaty that says we'll do no business with Japan, then Toyota has to abide by that in the state of Tennessee.
No matter what state they're in.
Yeah, no matter what state they're in. The second thing would be federal laws that Congress passes. Well, if Congress, now, it doesn't apply to anything they pass because they can pass a law that's unconstitutional. But if the law they pass is constitutional, for example, then that's the supreme law. Okay. The third thing, and the only three things that apply, the third thing is the U.S. Constitution. And that's where people say, see? I told you, the U.S. Constitution is the supreme law. The Supreme Court said this. Now, this is where I'm embarrassed to say even lawyers don't know this. Now, I think some do, but they like to use Supreme Court decisions for political reasons. So it's helpful if I can get you to think the decision is a law, not the reason for a judgment.
Right.
Because then I can take advantage of you politically. Or if I'm a governor or a state legislator and I don't want to have to deal with something, I can use the decision and the judgment to wash my hands and say, well, I just can't do anything. Well, it's not true either. And that's what Abraham Lincoln said. When we allow judgments of courts to be treated as if they've made policy for the whole country, we have become servants of the Supreme Court. And people do that for political reasons.
Yeah. Congress or a convention of the states has the ability to amend the U.S. Constitution and create new parts of the U.S. Constitution. Right. The Supreme Court of the United States does not have the ability to do that.
That's right. And even Congress can't do it. They can propose amendments and the states can adopt them, or they can call conventions, or the states can. But the Constitution belongs to the people. Mm-hmm. And the powers of everybody under the Constitution are subject to the powers of the people expressed in the Constitution. So, well, what is a court? Wait a minute, David. Then that doesn't make sense. The Supreme Court rules on things all the time, and we do things because the Supreme Court ruled as if they made a law. Well, we need to appreciate what happens there. The Supreme Court only has the power to enter orders and judgments. So we're in the middle of a lawsuit, and they enter an order that says, Gary, you must submit to a deposition. Okay, then I have to obey that. Or the court can hold me in contempt of court. Then at the end of the day, when all the depositions are taken and the trial is over, then the court enters a judgment and says, okay, here's what happens. That's not a law. That's the judgment that resolves that dispute. So what happened with Obergefell versus Hodges? And this is again where people get confused. There were actually 4 cases that went to the United States Supreme Court back in June of 2015. There was one filed against the state of Tennessee called Tanko v. Haslam. Very few people have heard of it. In fact, most lawyers haven't heard of it. But that was the case that involved the state of Tennessee as a party. There was a case filed against Governor Beshear and Governor DeBoer and the Commissioner of Health in Ohio named Hodges by a guy named Obergefell. And one case involved Tennessee law, one involved Kentucky, Michigan, and Ohio law. Okay, the Sixth Circuit said all of our laws were fine. So all 4 cases go to the United States Supreme Court. And because the first case listed on the docket is called Obergefell versus Hodges, everybody says, oh, that's the Obergefell decision.
Right.
Okay. So the Supreme Court looks at all the various laws and says, here's what we think they mean. This is what we think the Constitution means. And what they said is people have a right under the Due Process Clause to marry, a liberty right to marry, regardless of their sex. And because they have a right to marry regardless of their sex, then obviously a law that's based on sex violates equal protection. I mean, it's just sort of because there's a due process liberty right, then you can't discriminate based on sex. If there was no right to the marriage, then you could. If marriage by itself is defined as a man and a woman, now there's not an equal protection issue. Okay? It's only an equal protection issue because we said there's a due process right for any 2 people to marry. Now that's a very, very important thing, because what you're going to hear the gay lobby say is equal protection of the law, equal protection of the law. But the first point, the critical point, the predicate to the equal protection claim was that marriage is a relationship without regard to sex. and the biological sex of people is irrelevant to marriage. That's why it violates the Equal Protection Clause. Okay, now, that's just stuff for people to know. So the Supreme Court issues this ruling, says there's a due process, liberty, right to marry, okay? And because there is a right to marry that goes across the nation, states must recognize that. We don't have different kinds of state laws, you know, where in Tennessee 2 people can marry, maybe in California 3 people can marry. Now what do? Do we have to recognize a California polygamous marriage or Utah polygamous marriage, so forth? But anyway, so when the Supreme Court rules, they send what's called a mandate down to the Circuit Court of Appeals, which they did to the Sixth Circuit, and the Sixth Circuit sends the mandate down to the trial court, where the actual power is going to finally be applied to the parties to enter a judgment to resolve their dispute. And that's where the judicial power is finally exercised. So in my little hand over here, and what I sent to the county clerks, and I've given to the governor, is a document that says Final Order and Permanent Injunction. Okay? Mm-hmm. Now that's actually on August 24th of 2015. Obergefell was
2 months after the decision actually came down.
Yeah, almost exactly 2 months after the decision. This is what finally decides what Tennessee must do. So, anyway, in that,
which just goes to show the point. If the decision in June by the Supreme Court, was it June or July?
June.
Yeah, if the decision in June by the Supreme Court is all of a sudden the supreme law of the land, then why does the federal court still feel it necessary to issue a final, order in August?
Right, because it's now having to actually apply.
Yeah.
And resolve the dispute.
I'm just making the point for people to realize that what happened in June did not all of a sudden become the law of the land.
No, it didn't.
Yeah.
That's right. So what happens is the Supreme Court issues an opinion and says this is what we think it is. Now, the Supremacy Clause doesn't say the Constitution and the opinions of the United States Supreme Court and the laws of Congress and treaties. It just says the Constitution. And by analogy, I would say to people, if you read textbooks that talked about Jean-Jacques Rousseau or Hobbes or Locke or any of those guys, and you read commentaries and books about what they wrote, they may be right. They may not be. You ought to go read Rousseau. You ought to read Locke. You ought to read Hobbes and say, oh, well, they really didn't say that. Or I think the guy misunderstood his point. Same thing's true with Scripture. We can read commentaries, but you always go back to the Bible, to the original source document. So what the Supremacy Clause is saying is the Constitution itself is always supreme, not opinions about it, not commentaries about it, because the court has no power to amend the U.S. Constitution. It belongs to the people. And so Congress can propose amendments to the states, or the states can call conventions, but I can't change the Constitution. So we confuse opinions of the court with the Constitution, and then we take that confusion and put it into the Supremacy Clause and say, oh, the Supreme Court said there's a right to marry, so I get to marry, and what kind of idiot do you think you are that I can't get a marriage license? Because the Supreme Court said so.
Yeah.
Well, they said you had a right to marry. Now, I'm going to come back to that, or how do you exercise your right to marry? But in Tennessee, the only plaintiffs were 4 same-sex couples who had married outside of Tennessee. They moved to Tennessee, and I'm sure for tax return purposes or some reason that they wanted to be considered married. And the state constitution says we don't consider you married, even if your marriage was lawful in New York or New Jersey or California. If it violates our law, our Constitution's definition of marriage, you're not married. So they sued. They sued Governor Haslam. And Governor Haslam lost in the Supreme Court. So when the case came back to the federal court, here's what's interesting that happens. Now, we have a video on this that does all of what I'm talking about in about 6 minutes.
Yeah.
But the plaintiffs who had sued the governor said, we want you to enjoin the entire marriage amendment or all the provisions in Tennessee's Constitution regarding marriage. The Attorney General filed a response to that. He said to the judge, you can't do that. I have it right here in my hand. I sent this to the county clerks. He said plaintiffs did not seek a declaration that under the 14th Amendment, a state may not exclude same-sex couples from civil marriage. I said they didn't ask for me to say, or for you, Judge, to say, you can't exclude them from civil marriage. Nor did the plaintiffs seek a wholesale invalidation of Tennessee Constitution Article 11, Section 18. In other words, Judge, you only have judicial power over the parties and only with respect to the laws the parties have challenged. Marriage licenses are issued by county clerks. You didn't sue a county clerk. You have no authority to tell a county clerk what to do or what the license law is. In fact, they didn't even challenge the license law. The judge, now this is in August 11th. This is about, 6 weeks after the Attorney General told everybody, go ahead and issue marriage licenses. He then goes into federal court and says, no, you can't enjoin the whole Constitution of Tennessee. You can't enjoin the first sentence that says marriage is a historical institution and legal contract solemnizing relationship between a man and a woman. Second sentence, any policy, law, or judicial interpretation to the contrary is void and unenforceable. The court then says, in its brief on August 24th, in its memorandum, the court says the plaintiffs argue that we have the authority to do this. They said, but that exceeds the relief they've requested. See, I don't have a controversy to resolve regarding a clerk in the license law. She said, the Constitution, the law does not permit the court to rewrite the scope of the lawsuit.
Yeah, this is the federal judge.
This is the federal
Alita
judge.
Trauger.
Yes.
And she's acknowledging, like, look, I hear your plight.
Yeah.
But as a judge, as a court, I only have the authority to issue a judgment based on what you brought before me. I don't have the ability to start creating lawsuits on my own and judging things just because I feel like they need to be judged. I have the ability to judge what's in front of me. And
that's right.
And what's in front of me is not whether or not you can be licensed. What's in front of me is whether or not Tennessee needs to recognize your out-of-state marriage.
Your out-of-state license.
Right.
That's right. So she enters a judgment that says exactly that. So at that
point, the federal judge and our attorney general are in agreement.
That's right.
On this point.
Right. Now, what the Attorney General's telling the federal judge in August is not what he told the county clerks in June.
Right.
He said, just disregard it. But then he told the judge, now you can't enjoin it. You can't excuse anybody from enforcing it. You don't have any authority over that. So where did the Attorney General get the authority to tell people, state officials, to disregard the Tennessee Constitution? He's not a judge. He's not the legislature. What about county clerks? Well, I took an oath to uphold the Constitution. Right, the Constitution, not the opinions of the Supreme Court. But here's the problem, Mr. Clerk. You are a clerk. You're an administrative officer. You make sure all the boxes are filled in, all the information's complete, and it's signed, and you file it, and you issue a license. You have no authority to interpret the Supreme Court's opinion regarding the laws of Ohio or Kentucky and Michigan, decide how those apply to the law of Tennessee, and then disregard the Tennessee Constitution and the words male and female in the statute, because you're not a judge, Mr. County Clerk. That's a violation of the separation of powers. You've usurped the power of the state and the federal judiciary to interpret laws. And by taking the words male and female out of the statute on your own, out of your head, because they're still in there, you have also acted as if you can amend a state statute, and you never got elected to the General Assembly. Now, did you take your oath to the state of Tennessee seriously or not? Did you say, I will uphold the Tennessee Constitution? Yeah, but I took an oath to uphold the federal Constitution. Right, the federal Constitution, not the opinions of the Supreme Court. Obey your oath.
So let's talk about that.
Sorry, I get a little exercise here.
It's all good. But what you said right there when you said, you weren't elected to Congress, to the General Assembly.
That's right.
You don't have the ability to
not
make
a judge.
Laws. Right.
That's right.
So on that point, let's talk about who makes laws in the state of Tennessee, and then let's talk about you've got this thing here when back to the Supremacy Clause, and when there's an issue with the 14th Amendment, who addresses that? Is it the court, or who is it? So let's really talk about the powers of the lawmaking bodies, because honestly, the way I look at that, all of these when the court makes a decision like this and people begin to take court decisions as if they're law, what has happened is the power has been completely removed from the people.
Right.
I mean, the whole point of the way this is set up is that these things go through our lawmaking bodies. In Tennessee, they go through our General Assembly. In the United States, they go through our Congress. And the reason that they do is because that is the power of the people. They are our representatives. We elect these people, and they make the laws that we must abide by.
Right.
That's why the court doesn't do it. It's why the president doesn't do it. It's why the governor doesn't do it.
That's why county clerks don't do it.
That's right.
That's right.
The representatives elected by the people make the laws that we must follow.
Sure. Now, before we get to this question of who's supposed to fix the problem, let's notice something else here. The Tennessee Constitution says in Article 7, Section 1, the people of Tennessee said, here's how we want to establish ourselves. We're going to elect sheriffs and county officials, so county commissions. We're going to elect county trustees. We're going to elect county clerks. And then it says, their duties shall be prescribed by the General Assembly.
Essentially by the people.
Essentially, indirectly,
right,
by our representatives.
Yeah.
So we have to, by Constitution, elect a county clerk. If the General Assembly says, I think this is a useless office, I'm not going to prescribe any duties, we'd elect a county clerk who sits home because he has no duties. We wouldn't pass a budget because he has no duties. So the General Assembly gets to decide that. Does that mean the Supreme Court gets to decide that? No. Why can the Supreme Court not decide that? The Supreme Court can say you have a right to marry. Let's assume they even say you had a right to marry under Tennessee law. Is it the Supreme Court's power to decide who issues the license?
No.
Can the county clerk say, well, I issued a license for this definition of marriage. Why don't I just issue it for that definition of marriage? Because the two definitions are different, and I've not yet decided as a member of General Assembly whether I want you issuing those licenses. The General Assembly could say, theoretically, in response to Obergefell, if the governor of Tennessee, Haslam, was going to abdicate our state sovereignty, I want him to issue every marriage license. So, Governor, just set up in your office the marriage license division, and I'm going to give you that duty to execute all marriage licenses in the state of Tennessee. There we go. It wasn't the court's job to do that. It wasn't the clerk's job to assume because I can license this, I can license that. That's not their job. I mean, nobody's upholding the Constitution.
And that's the part, so as much as you get fired up about the part that I get fired up about is, especially in Tennessee, we have a governor, we have an attorney general, we have county clerks, we have members of the General Assembly, all of which are refusing to follow the laws set before them in the state of Tennessee.
Now I will make one exception to that. Don't say that to embarrass you. But the General Assembly's not changed the law at all. Because I've been saying, don't change the law, don't change the law. You're under no duty to change the law. The problem is the General Assembly doesn't have any power to do anything. They've already got a law. They don't need a new law. The law's not been enjoined. It's not been amended. It's that everybody else who administers the law.
Gotcha. Beyond creating the law, they've now lost the ability to do anything.
What am I going to do? Gotcha. Now I'll tell you. Back when Haslam was doing this, some of the people who got mad at me because I wouldn't support a new law, I said, we don't need a new law. The old law's never been replaced. I looked at him and I said, why don't you just impeach the governor?
Right, because that's the question, right? What do you do whenever everyone whose responsibility it is to administrate the law that's been passed won't do that?
Right. So
what do you do then? So,
for example, the legislature said that local office holders can be ousted from office if 10 citizens file a petition and say you're breaking the law. So some of these people got so mad at me years ago and said, we need to pass a new law. We need to pass a new law. I said, well, I'll write the petition for you. Go down to the courthouse. 10 of you oust your county clerk. Well, I don't want to do that. Well, that's your remedy. The legislature gave you a remedy. The legislature itself doesn't have a remedy. What am I going to do? Pass the same law, pass the law, same law, same law, same law, and just let everybody keep violating it? What's the point?
Yeah.
I've got a law. Enforce it.
Yeah.
And if you get sued, we'll defend it. So I don't fault the legislature. I point the finger at other people. And I really don't point the finger at county clerks, because county clerks are not lawyers. They got elected to handle paperwork. And I don't mean to demean what they do, but they don't exercise a lot of policy discretion. They look and make sure, did you sign the form? Did it get notarized? That kind of stuff. And they file things. And then when people want copies, they make sure that you're entitled to get a copy, and they give you copies, and they charge you money for it. So they didn't get into this to make policy. They didn't get into it to be judges. And so when the Attorney General, the day of the opinion, by 2 o'clock, well, actually 10:37 in that morning, said, y'all start issuing licenses, they said, well, he's the state's Attorney General. I guess he knows what he's doing. I might as well go ahead and do it.
Yeah, except he's not my boss.
Except he's not my boss, and he's not really my attorney, and he can't prescribe any duties to me. But he
he must know what he's talking about.
He must know what he's talking about. Yeah. So then he goes into court, 6 weeks later, and tells the federal court, you can't enjoin the provision that says any policy law or judicial interpretation that applies to licensing is unconstitutional. So that's where we have this mess. Now, so the point is, court opinions are not the Constitution. Don't throw an opinion in my face and say, that's the law, that's the Constitution.
Supremacy clause.
It's not. Now, let's make this drive the point home even further. The 14th Amendment says who is supposed to remedy violations of the 14th Amendment. Okay? So we have another video coming out where I said, wouldn't it be nice if people actually read the directions? Some of us have tried to assemble, a bike at Christmas, and we're hurried.
I'm going to just go ahead and admit I don't read directions.
Okay. And a lot of times I don't. I think, well, this looks intuitive, Yeah. And then there's this part over here, and it's like, I can't get it in there. I got to take it in.
But in this case, we really should.
But when it comes to the Constitution, you should read it. So the Constitution actually says who is to fix violations of the 14th Amendment. Now let's go back and talk again about the dispute. So I didn't pay you this month, and you sued me for your paycheck. The court determines I breached our employment agreement. And what do? They remedy the breach by ordering me to pay you that $500 for your month's work. Okay? And that's appropriate. The court should be able to remedy breaches of the law. But when the 14th Amendment is breached, the 14th Amendment says who is to remedy it. So I think one of us has it right here. Oh, yeah. Do you have it right there? Just
it says the Congress shall have the power to enforce by appropriate legislation the provisions of this article.
That's Clause 5.
Speaking to the 14th Amendment. Yeah. Clause 5 of the 14th Amendment.
Yeah. Did it say the Congress and the judiciary?
I didn't hear that.
You didn't hear? Yeah, I didn't read that. It's not in there. It says Congress shall have the power.
Right.
Now, here's what's fascinating about that. The United States Supreme Court said not long after the 14th Amendment was passed, they said this, and now I'm quoting, audience, were it not for the 5th section of the amendment, what you just read, there might be room for the argument that the first section about don't violate due process and liberty and equal protection is only declaratory of the moral duty of the state, as we said in an earlier opinion. Well, you really ought to let people marry. But here's the problem. The Supreme Court, when they say you have a right to marry, why can they not enforce the right? Because if it's a license, somebody's got to authorize the license. That requires legislation. Can courts pass legislation? No.
Can courts force anyone to legislate?
No, because that's a separation of powers issue, right?
Right. They can't force Tennessee to make a law.
That's right. Nobody.
They can't force Congress to make a law.
That's right. Even the Tennessee Supreme Court has said this exact same thing. You may have a right to something in the Constitution, but if it requires enabling legislation, then we can't do anything. Legislature may never do it. You may be mad as a hornet, but I'm sorry. I don't have the power to make anybody pass a law. Okay. So the court said you have a 14th Amendment due process right to marry. The question I kept asking from the beginning is, well, then how do you do it? I know how you get married if you want to get married under the state law,
right? But
I don't know how you get married under the federal law. Well, there's a huge sovereignty issue, isn't it? Why should the state of government provide marriage licenses to implement federal marriage policy?
Right.
I'm not your puppet. I'm not down here to do your business for you. You want to send me money to run my clerk's office and handle all the divorces and all that stuff. That's fine, but I'm not going to do your job for you. You want marriage? You've got it. Go ask Marsha Blackburn how you do it.
That completely disintegrates states' rights and the idea of dual sovereignty.
Absolutely.
That completely goes away in this
We're just a
scenario.
puppet to them.
Yeah.
You know. Now, again, we talk about political reasons for doing things. Why will somebody come out and say, well, the Supreme Court issued a ruling? Why? Because they don't want to have to upset people by saying, not only do I not want to do this, not only can't I do this, people say, why can't you do it? Because my state constitution says I can't. So I'm just going to pass the buck and blame the Supreme Court, argue the Supremacy Clause, and hope people don't listen to God, law, and liberty, because otherwise they'll know that.
Hope people don't pay attention to this and crazy Fowler guy.
Yeah, well, see, I'm not crazy, because there's actually a bunch of law professors working with me. And
Exactly.
a bunch of them have stated all this stuff.
Yep.
Yeah.
Maybe, one right has taught constitutional law for 27 years at Notre Dame. Yeah. So these aren't like just
One clerk for Clarence Thomas, I assume he'd probably be pretty good too.
Yeah.
His resume is 119 pages. So
yeah.
I'll
no
defer to-
offense for folks who get their law degree through night school, but that's not the way these guys got their law degree.
Yeah, I didn't get some big law degree, law school law degree, but anyway, that's important. Now, here's the other thing that's important. So, David, are you saying that if same-sex couples want to get a 14th Amendment due process marriage, they need to go to Marsha Blackburn? Remember, I mentioned her earlier, and go to Mark Green and say, would y'all pass a federal marriage licensing law so I can get a license? Because Tennessee says, not only do I not have to do it, but my state constitution prohibits me from doing it. And the Supreme Court can't make me do it. So we're just not going to do it for you. The answer to the question is, sorry, you're out of luck again. Well, why? You just said Congress has the power to enforce. The Supreme Court has also made it very clear. What the law is that no state shall pass a law. And so the power of Congress is to prohibit state laws, not commandeer states to say you will pass a law.
Right.
So if you read through the powers of Congress, they have no power over marriage. So Congressman Green and Senator Blackburn would be right to say, I'd really love for you to be able to get married. And I know the Supreme Court said the federal Constitution gives you a right to marry. But my power under the 14th Amendment and Clause 5 is to prohibit the state law from passing a law that doesn't allow you to marry. But they hadn't passed a law that doesn't allow you to marry. They don't have to have a law to let you marry. They don't have to license any marriages. And if you want one from me in Congress, I don't have any power under the powers of Congress to deal with marriage. I guess you need to ask the Supreme Court how you get married. But now when the Supreme Court says, well, Congress does have the power or whatever it is, now they have to understand that every divorce, every child support payment, every visitation issue is now a federal issue that will go to federal court.
Right. And that's the big thing I think that people don't get. That's one of the main things I learned in this issue is that the Obergefell decision essentially created, which had never been the case before, it created a federal marriage.
Yeah.
It created a 14th Amendment federal marriage, which no state is under any obligation whatsoever to license.
That's right.
And so the way this should be done is if the federal government wants to be in the business of creating a right to marry by federal law, well, then the federal government needs to put federal agents wherever it wants to, in any state it wants to. Sure. But it needs to put, just like it has they have Social Security offices,
sure.
They have, Veterans Affairs offices, they have all these things that the federal government runs.
They need to create the federal marriage.
They need to create the federal marriage office, and you go down to the federal marriage office and you get your federal marriage license. And then when you want to get divorced and you need child support and all that stuff, you go to federal court.
Yeah.
What a mess.
Oh, absolutely. But here's the problem again, I'd say. Congress has no power to create. They can create Social Security. They can create Veterans Affairs. They can create post office, but they can't create anything about marriage. Mm-hmm. So So this whole thing, what we're doing is we're saying the king has no clothes, and everybody's been tromping around saying, "Oh, isn't his robe beautiful?" And it's like, no, that was his rear end. It's naked, and nobody wants to look at that, and they don't want me calling it out, and I get that. But we have to understand we're messing here with the way our government functions. I hate that it came up in the context of a socially controversial issue.
Yeah.
But if this were a gun right case, if this was an automobile license driving case, if this was another case telling, well, we've had these cases. The states have fought them. When Congress passed laws saying you must do certain things for the licensing of handguns, states said, mm-mm. When they've passed environmental regulations and said your state must do such and such, the states have sued from time to time and said, mm-mm.
Right.
We don't have to do that. You can't commandeer. In fact, just the year before, Congress got their hands slapped because they told states they couldn't allow gambling. Well, if you have control over gambling, Congress, do it yourself. But don't tell the states what they can do. So this, to me, what's happened over the last 4 years is the biggest abdication of state sovereignty to the federal government, and not even to Congress, not even to the president, but to a body that only has the power to issue judgments to resolve disputes between particular parties, and it is horrendous. So I don't care what you think about gay marriage. You ought to care about the way we govern ourselves. You ought not to allow this kind of precedent for responding to the Supreme Court to stand.
And what does it say that the states are willing to give up those rights because they're scared of the gay lobby?
That's what it is.
God forbid we make these people mad, and we've got to
boycott our state.
Yeah. Oh man, that'd be terrible.
Yeah. I'd rather give up our form of government.
I'd rather give up my sovereignty.
In my form of government, the way we govern ourselves, to avoid that.
Yep. I'd rather go ahead and pretend that the Supreme Court makes laws and is truly sovereign and supreme over everyone.
Clause 5 doesn't apply. County clerks can be ordered to do things that the legislators never prescribed them to do. This is a constitutional mess, and we've stuck our finger in it. I hope America wakes up and the people of Tennessee wake up, and we'll see.
Yeah. There are people that are gay, but that also greatly value liberty and the idea of our republic.
Sure.
And so I would love to hear from some people that, are in fact gay and obviously would support gay marriage, but can also realize that we have created an absolute mess. And the way we're going about this is lawless, and it needs to stop.
Yeah, it needs to stop. We need to address it.
People who administrate laws need to administrate the laws that Congress has put on the books, that the General Assembly of Tennessee has put on the books, that were elected by the people.
Yeah.
That's what needs to happen.
Sure. And when a court enjoins that law and says it's not good,
when and if it does,
then we have no law.
We've got to make a new one.
We need to make a new one.
Right. That's our responsibility to make a new one.
That's right. So it's as Lincoln said, we will use court opinions for political purposes because why? We don't want to have to bother with repealing the Tennessee Constitution. We don't want to bother with having a lawsuit and having to defend it and argue for our state sovereignty. Let's just go along and everybody will be fine and nice.
So in the most polite way possible, you now know where you can go stick your supremacy clause.
Yeah. And you can stick it right underneath Clause 5 of the 14th Amendment.
Nice.
Okay.
Well said.
Okay.
All right. Thanks for joining us today. And hey, again, we would any questions, comments. We'd love your input. You can always email info@factn.org, and we'd love to hear from you. Thanks for joining us.
If you enjoyed this episode, don't forget to subscribe. And if you want to help spread the word, please give us a 5-star review and tell your friends to subscribe too. We're available on Apple Podcasts, Spotify, and wherever you listen to podcasts. God, Law, and Liberty is a podcast of the Family Action Council of Tennessee. We are a 100% supporter-funded nonprofit advocating for family, life, marriage, and religious liberty. For more information, please visit us at www.facttennessee.org. That's FACTennessee.org. And please follow us on Facebook, Twitter, and Instagram at Fact Tennessee.